Welcome to this explainer. Today we're jumping right into a landmark constitutional court case from the year 2000 that tackled a massive, literal clash of fundamental rights. The case is Christian Education South Africa versus the Minister of Education. It's a genuinely fascinating look at what happens when the deeply held religious beliefs of a community collide head-on with a newly democratic state's absolute mandate to protect its most vulnerable citizens. We're going to explore exactly how a society balances the freedom to practice one's faith against the right to human dignity.
We'll be unpacking this case across 5 key areas. 1. The core conflict. 2. The case for religion. 3. The duty to protect. 4. The balancing act. And 5. The final verdict.
Section 1. The core conflict. A clash of fundamental rights. So, can religious freedom actually exempt you from the law? That is the profound central question triggered when the South African Schools Act of 1996 was passed. This isn't just some theoretical debate. It asks whether a specific group of believers can claim an automatic right to be exempted by their beliefs from the general laws of the land. How far can, and really how far must, a democracy go in allowing religious communities to define for themselves which laws they will obey? Well, the conflict ignited over this specific piece of legislation. The South African Schools Act explicitly banned corporal punishment in all schools. And the law didn't just frown upon the practice, it made it a criminal offense. Breaking this rule meant you could literally face assault charges. But then we have Christian Education South Africa. They're an umbrella body representing 196 independent schools and roughly 14,500 students, and they decided to challenge this blanket ban. They had been operating in South Africa since 1983, trying to provide an environment in keeping with their Christian faith. Now, they didn't want to strike down the whole law for everyone. Instead, they were seeking a specific exemption just for their independent schools, where parents had explicitly consented to the practice. Section 2. The case for religion, sincere beliefs, and scripture. What's really interesting here is how deeply rooted the appellant's legal case was in their sincere religious convictions. They heavily cited biblical scriptures, like Proverbs and Deuteronomy, to argue that physical, corporal correction, as they called it, was a vital, non-negotiable aspect of their Christian faith. For these parents, this absolutely wasn't about a preference for strict discipline. They believed they had a divinely imposed responsibility for the upbringing of their children. To leave misdeeds unpunished would literally be defying their scriptures. Imagine your core community practices suddenly being outlawed. The parents argued this ban directly violated their constitutional rights, specifically Section 15, which guarantees freedom of religion, and Section 31, protecting their right to practice it together. They argued that their schools maintained an active Christian ethos, and a blanket prohibition on their disciplinary practices invaded their individual, parental, and community rights to freely practice their faith. They genuinely believed they had a divine duty to shape their children's character. And they enacted this by formally delegating disciplinary authority to the teachers. Parents would actually sign a document acknowledging that corporal punishment was inseparable from their faith. The schools even had a highly structured procedure for the whole thing. They'd investigate the offense, get a witness of the same sex, discuss the biblical principle violated, administer up to 5 strokes with a cane or ruler, and then conclude with a prayer and a hug to reaffirm the relationship. They argued this was a clear expression of love and guidance, not abuse. Section 3. The duty to protect, transforming the education system. Okay, let's step over to the other side of the courtroom. The state countered by invoking its own robust set of constitutional obligations. They pointed out that corporal punishment in schools violates a child's right to equality, their human dignity, their right to be free from all forms of violence, and their specific rights under Section 28 to be protected from maltreatment or degradation. The state argued that physical punishment is inherently violent and involves a degrading assault upon a person's physical, emotional, and psychological integrity. The state also made the case that banning corporal punishment was a deliberate, highly symbolic move. They were trying to transition away from the institutionalized violence of South Africa's history. In the past, state policy permitted physical punishment in schools, prisons, and correctional institutions. This new constitutional order required a radically different approach. The Department of Education wanted to introduce new principles of learning, where problems were solved through reason rather than force, putting the child right at the center of the educational experience. Plus, South Africa wasn't operating in a vacuum here. By ratifying international treaties like the UN Convention on the Rights of the Child and the Convention Against Torture, the state was legally bound to take all appropriate measures to protect children from physical or mental violence.
The state argued that the global trend in democratic countries was firmly moving toward the complete abolition of corporal punishment in schools. Section 4. The balancing act, weighing competing values.
So how exactly does a democratic society decide who wins when both sides have incredibly valid, deeply held constitutional claims? The Constitutional Court had to carefully place these immensely important but competing values right onto the scales of justice. As Justice Sachs noted in the ruling, the competing interests belong to completely different conceptual orders. On one side, you have religious conviction based on faith and the rights of a community. On the other side, you have the state's secular, reasonable duty to protect children from physical harm and indignity in an institutional setting.
To solve this giant puzzle, Justice Sachs utilized the Section 36 Limitations Clause to perform a delicate proportionality test. It's a nuanced balancing act. The court assumed, for the sake of the argument, that the parents' religious rights were indeed being limited, and then asked the big question: is this limitation reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom? This structured test requires stepping through 4 specific factors. The court absolutely acknowledged the massive importance of religious freedom and didn't doubt the parents' sincerity for a second. But they had to ask, was there a less restrictive way to achieve a nonviolent school system without a blanket ban? The state argued no. Allowing even a few exemptions would destroy the symbolic, moral, and pedagogical purpose of the new law, and it would make monitoring against actual child abuse nearly impossible.
Section 5, the final verdict, the court's conclusion.
All right, let's look at how the court ultimately ruled on this incredibly complex dilemma. The court recognized the parents' sincerity, but noted a crucial distinction. The law only restricted one specific physical act in a public setting. It did not restrict their overall religious lifestyle. Parents weren't being forced to make an absolute choice between obeying the law and following their conscience. They can still raise their kids according to their beliefs. They are just prevented from empowering teachers to administer physical beatings on school premises. Schools, even independent ones, function in the public domain and must adapt to non-discriminatory laws regarding health, safety, and basic human dignity. And this brilliantly illustrates the final verdict. When all the factors were weighed together, the state's paramount duty to establish a nonviolent educational system completely outweighed the request for a religious exemption. Justice Sachs made it clear that while religious freedom is a cornerstone of a pluralistic society, the state's obligation to protect children from violence and indignity in an institutionalized setting, like a school, is absolute. The appeal was officially dismissed. Interestingly, Justice Sachs ended the judgment with a really poignant postscript. He noted the complete absence of the children's actual voices in the courtroom. No independent curator was appointed to represent the students. And remember, some of these pupils were in their late teens, entirely capable of articulating their own views on their dignity, their faith, and their bodies. It leaves us to wonder how the youth themselves viewed this clash of rights. And it leaves us with a critical question to ponder long after this explainer ends. When the religious rights of the parent collide with the protective duties of the state, who is truly ensuring that the voice of the child is heard?